Yeah, good morning, everyone. And as usual, today's webinar series is there. And today something very unique topic, which is not much talked or discussed about. It's insight into the special courts. Honestly, many times we get confused special courts, which will be the court, where we have to go, how it will be done, which will be the process. And we get confused. And so this topic. The topic is very small, and when the topic is small, there are more questions. And there should be some experienced person to answer that. And who else we can have other than Dr. K.S. Ravichandran, a very experienced company secretary and specialized on the topic. Everyone knows him, and we are fortunate to have him as a panelist today. Welcome, Mr. Ravi. Thanks a lot for your time. As to formally introduce Mr. Ravichandran, Dr. K.S. Ravichandran is MCOM, LLB, FCS, PhD. He is the founder and managing partner of KSR company, KSR Company LLB, Coimbatore, Bangalore, and Chennai. He is an expert in company law, security laws, regulations, laws relating to FEMA-related rules, regulation, industrial law, environment law. Area of specialization include board processes, governance, audit, compliance, solution, corporate restructuring, dispute resolution, IPR, merger acquisition, insolvency, bankruptcy, and arbitration conciliation. He has appeared before various regulatory authorities, tribunals such as NCLT, NCLAT, DRT, and intellectual property. Next, please. He has addressed several conferences, seminars, and workshops and written more than 1,000 articles on corporate laws. He has authored several books, including second edition of Duties and Liabilities of Directors, 2024, second edition of CSR, ESG, and Charitable Institution, a wonderful book, one should refer that. Third edition of Related Party Transaction, 2024. Friends, these all are really wonderful book one has to go through. Apart from the above, his works include a treatise on contraventions under Companies Act, Securities Law, and FEMA, 2021, CSR, Emerging Opportunities and Challenges in India, the law relating to LLP in India, a treatise on corporate lending, charges, debt recovery, enforcement of security interest, and winding up of companies. So, friends, he holds a doctorate from Department of Management, Alagappa University, on prosecution of directors under the company law and criminal law in India and UK. Wonderful. He was a member of expert subgroup constituted by MCA for studying the suggestions relating to chapters of the Companies Act 2013. He was a member of Secretary Standard Board of ICSI. He served the Indian Air Force. Friends, this is something very unique you will find. He served the Indian Air Force for more than 9 years as a specialist in Russian radar system. He holds a diploma in electronics and radio communications engineering and a diploma in technology. He was a lecturer at Jawaharlal Nehru College, Arunachal Pradesh. He was independent director of Karur Vysya Bank Limited for 8 years. He chairs the Corporate Law Council of SOCHAM. His profile is so long and so rich. Please, next. So, thanks a lot, Mr. Ravi, for your time. We have with us Mr. Sudhakar and Mr. Bala, and our Alifia Sapatwala partner is also there. And today's our presenter is Asta, and Asta is going IBC manager Mehta and Mehta, Asta Kanodia. So I'll request Mr. Ravi to say a few words on the topic, then Mr. Sudhakar, then Mr. Bala, and Asta, you can start your presentation. Thanks a lot. Thank you, everyone. Over to Mr. Ravi to say a few words on the topic, please.
Topic is interesting, as he said, because it is about special courts. The approach to the topic must be, in my opinion, whenever we talk about offenses and prosecution, particularly serious offenses involving imprisonment, the most important thing that we look at, in my opinion, is which is the definition of the offense. How do courts nail that this offense has happened? It's a criminal offense. It has to be thoroughly examined. It has to undergo the trial process. It has to withstand the test of the court, and ultimately, the ingredients of the offense have to be strictly construed and they should be achieved. So, therefore, whatever we are dealing with offenses and prosecution, the most important thing is, do we encounter a situation where an offense has been committed and that offense is made out or capable of being made out, and the ingredients of the offense are thoroughly met. This is the first and foremost requirement in order to work in this space. Definition of the offense, whether you are working for the prosecution or you are working for the defense, the most important thing is identify and be sure whether ingredients are met or not. Accordingly, you will be able to work for the achievement of the purpose of the prosecution, taking the prosecution to the logical conclusion and desired destination. When we discuss about offenses and prosecution, immediately what comes to our mind is four things. Number one, how do we provide relief to the directors and officers in case you think they are not actually involved in the crime? As a company secretary in practice, we may not be able to sit alongside the prosecution, whereas we will be more often sitting alongside the people accused of offense. Could be a practicing company secretary, could be a chartered accountant in advice to the company or audit to the company, could be a director, managing director, non-executive director, independent director, a KMP, SMP, any person. Therefore, more often we tend to be alongside the people who are accused to support them, to find ways and means of understanding the case and providing whatever relief that is possible in accordance with law. The second thing is whether the relief could be in the form of adjudication of penalties or compounding of offenses. The third thing would be, in order to, if suppose something is there and you cannot achieve the desired result, whether there is a possibility for toning down, reducing the punishment. These are all the three ways in which it is dealt. In order to do that, we should have a complete ecosystem understanding. The prosecution side. The prosecution side is going to come out all way with full force to nail the accused about the crime and get the punishment. That is their job. So the prosecution's desired destination is to get pronounced, the accused pronounced as guilty, and a sentence of punishment is awarded, whether by imprisonment or fine or both. So therefore, the approach of the prosecution is to succeed in the prosecution. Any lacuna in the process and procedures is going to be costly to the prosecution. Therefore, there is always going to be an exaggeration of the definition of the crime. There is always going to be another important aspect from the prosecution side. Hundreds of people will be added as a peripheral people. They may not really be the person in charge of the offense or responsible for the affairs of the company, or they might not have ever contributed to the offense, or they might not have even colluded or connived or have granted consent for the offense. Therefore, the prosecution does two things generally. Number one, exaggerate, elaborate. Number two, add as many people as possible within the
Hello.
list of accused. So we have to understand that aspect also. The third thing is, when it comes to the accused, how do we deal with? Do we deal with outside the court? Can we deal with the court in the trial process? I think there are serious provisions There are provisions which can debar an officer or director from being officer of any company for whatsoever. So I will deal with all those things as and when it comes. I think this is the approach I thought I'll share it with you in my preface to this wonderful program organized by Mehta and Mehta. And I sincerely thank everyone here, Mehta and Mehta, partners and team, for this opportunity given to me to refresh my memory and take stock of the latest developments in the field and how do we enable the class of professionals in working in this area. Thank you very much.
Sudhakar, can you say
Yeah,
a few words on the topic, please?
yeah. Good morning, everyone. Apart from the profile, whatever Deepti has read about Dr. Ravichandran, I have to just say that he is one of the finest professionals whom we have in our profession, and really sometimes we have to feel pride about that. At the same point of time, whenever I talk to him, I used to say, "From which city you are now?" He is speaking to me because he travels so extensively and he is giving us 2 hours. Thanks very much, Dr. Ravichandran, for giving us from your busy schedule. Normally, we say it as a customary, but I know that how busy you are. And I told about when we started this masterclass, that time itself, I told him, wherever we are going to discuss about special codes, you must oblige us, and he obliged us. Apart from that, before taking about the subject, one or two announcements I want to make that you all must appreciate that we have started this masterclass on Companies Act, wherein we started from Section 2. And we started on 6th April 2024. Today is the 31st present webinar on this Companies Act. Next week is the last one. We are going to conclude this masterclass on Companies Act. And there are three chapters we have not covered. One is chapter 15, that is what's called arrangements, amalgamations, and the merger amalgamation. The second one is chapter, I think, 16, that is about the operational mismanagement, and chapter 20 about the producer companies. Why we are not taken is because we want to cover this thing in a special series of masterclass. One, we will be doing a corporate restructuring. At that point of time, we will take up merger amalgamations, liquidation, and all other related issues. So we are going to start a masterclass on issue of securities in 2025. Similarly, we are going to start a masterclass on corporate restructuring. Now, coming back as far as the topic is concerned, just one or two things only I would like to say that we all know about the compounding of offenses, and very few of us know the fine difference between the fine and penalty, what can be compounded and what cannot be compounded. And similarly, this kind of special courts, what is the nature of the special courts and what is the jurisdiction? So many things are there like this. Very few company secretaries, including me also, in the day-to-day life of the professional life of ours, we normally don't read these provisions. So I thought, okay, that we will have a special series, and especially this fraud. And next week we are going to have the miscellaneous provisions where we are going to touch about fraud and other things. In this one, I request Dr. Ravichandran to also throw a bit of more focus about the explaining about what is fine, what is penalty, how the compounding of offenses, what we can and what we can't. Because as we know that when Companies Act 2013 was legislated at that point of time, one of the major thing was this was, I used to say this is the draconian act after FERA 1974. The kind of penal provisions what was stipulated in this act was really nightmarish. Over a period of time, by these four amendments to the Companies Act, they have diluted the provisions. But the penal provisions I'm talking about, but they have not touched the criminal provisions. Not a single criminal provision, penal provision they have touched upon. So, as company secretaries, Dr. Ravichandran, I request you to please sensitize the professionals. What sort of precautions, what sort of care we have to take for ourselves as key managerial personnel, for ourselves as secretarial auditors, at the same point of time, how we have to insulate our directors also to the extent possible. So, with Dr. Bala, kindly take it forward. Thank you.
Good morning to all of you. I welcome you for this important seminar of today, especially on a Saturday morning. And it will be definitely going to be a very, very interesting session. I can already see you, more than 140 plus people are enrolled. That itself shows what is the importance of this particular session. Although I have been actually handling some of the issues, handle the issues also in my thing, but still, this topic is so wide. I really get many times confused because, as you know, when the act has actually decriminalized the various sections of the Companies Act, effective from 2nd November 2018, then the question actually arises, what happened to the offences which have been committed earlier to that, especially in the 1956 Act, and thereafter till 1st September 2018 under 2013 Act. Because there have been various compounding applications which have been filed in both the acts under Section 441 with the RD. And of course, after the 2013 Act has come, some applications have been also filed in the NCLT, and also some of the prosecution cases has been filed with the various criminal courts as well. Now, today, whether these old cases of 1956 Act, which is actually committed, and even prior to 1st November 2018 has been committed, whether adjudication can be done, what is the procedure, that is one thing still I am struggling to get a hand on it. Because there are different ways of dealing with the different ROCs, which I have seen. When it comes, I'll share with you. That is one thing I'm looking forward. And especially come to Dr. Ravichandran, as Dipti and Sudhakar puts it, excellent person, whom I know more than 3.5 decades actually. Because as people said, he served in the army. It is not the question of his serving in the army. He was actually sitting at the very high height of 9,000 plus MSL in the cold winter and pursuing his company secretary course. And after he took the retirement from the army, he started the company secretary profession. By great up to him. He started his things in Coimbatore and subsequently he enlarged his business in Bangalore and Chennai. And excellently he has been doing. I had an occasion to dealt with him in a very early 2000 in some of the money recovery cases where I was a company secretary, money recovery cases, those days, filing winding a petition with the companies, making the people to come to the negotiation table and recovering the money. Not only that, he has guided me excellently when one of the bigger companies who are involved in the money recovery cases in Coimbatore those days, that sort of the versatile personality he is. Today, really, I am looking forward to learn much more things today on the intricacies of this topic. Although I've been writing article, I am studying various things, etc. Still, there are a lot of if and buts, there are a lot of doubts, there are different ROCs are approaching different ways. All those things I am really looking forward to hear from him. I will not take more time than this. I will actually ask the presenter to make a presentation. Let us wait to hear his practical experiences and his mindset, what he thinks about his expert opinion. I think we'll be greatly learning from him today's webinar. Thanks you.
Yeah.
Thanks a lot, Ravichandran. It is very nice meeting you after such a long time.
Yeah, and I see the questions are started already before the session is started. Asta, please start sharing your screen, please, and start the presentation.
Thank you, everybody. Good morning to all the panelists and all the invitees and the people participated in the webinar today. My name is Asta Kanodia, and I'll be taking you through the presentation with the topic and insight into special courts. So in this presentation, we will thoroughly examine Chapter 28 of the Companies Act 2013, which governs the establishment, jurisdiction, and functioning of the special court in order to gain an in-depth understanding of Sections 435 to 446 of the Companies Act, specifically laying down the framework for special courts to address corporate offenses effectively. In Companies Act 2013, it is a comprehensive piece of legislation that governs the functioning of companies in India. As we all know, one of the key features of the Act is the establishment of the special court to handle corporate matters, particularly those involving fraud, mismanagement, and serious violations. Now, to first get an idea of what are special courts. The name special itself means something important. So special courts are designated courts that have been set up to deal with specific types of cases or offenses, which may require specialized knowledge of a focused approach due to their complexity or urgency. These courts are distinct from regular courts, which handle a broader range of legal matters. Special courts are usually established by the government or a legal system to address particular areas of law where specialized expertise is needed to ensure efficient and effective adjudication. Moving ahead, these are the relevant sections that fall under special courts as per Companies Act 2013. As we all know, this chapter specifically deals with the establishment and powers of special court in order to adjudicate corporate crimes, ensuring that the corporate offenses are addressed expeditiously and with expertise. This chapter is designed to handle violations of Companies Act, speed up the trial of these corporate offenses, which involve complex financial transactions, ensure greater accountability for corporate governance, and also maintain investor confidence. On screen, we can see the following sections that are going to be covered for the presentation ahead. The first and the foremost important section, that is section 435, is the establishment of the special courts. 435 of the Companies Act deals with the establishment, wherein the provision aims to expedite the legal process of cases related to companies, particularly those involving serious financial offenses. These special courts are designed to handle matters concerning to any fraudulent activities, whether mismanagement or corporate governance violations are involved or any other corporate offenses under the Companies Act. Now, the reason or the purpose for which these special courts were designated were majorly to expedite the justice, wherein special courts are being set up for a quicker disposal of corporate-related criminal crimes. Secondly, for focused expertise, wherein judges with experience in corporate law and financial crimes handle these areas. And lastly, reduction of burden on the regular courts. This helps to relieve regular courts by taking over specific types of corporate offenses. Moving ahead, we try to understand the powers of these special courts. Now, these special courts have the same powers in order to that as the ordinary criminal courts under the CRPC, that is, power to summon, issue warrants, and also enforce fines. Speedy trial of corporate-related offenses, and they can also award penalties or take any other action as that under Companies Act. The constitution of these special courts, the central government is responsible for designating and establishing special courts. They also appoint judges who possess relevant expertise in corporate law, financial crimes, and complex legal matters. Special courts also have the jurisdiction to hear and try offenses related to Companies Act, including fraud, financial misconduct, violations of corporate governance standards. Moving ahead, we understand the applicability of these special courts. Well, special courts are established primarily to handle offenses under Companies Act that have serious nature offense. The type of offenses typically handled by special courts include fraud under Section 447 of Companies Act, any false statements in documents, example under Section 34, 35, 36 of the Companies Act, and any other non-compliance with orders issued by regulatory authorities like SEBI or Ministry of Corporate Affairs. Moving further under Section 435, appointment of the judges. Now, this talks about the judges that are specifically appointed for the establishment of these special courts. Judges appointed to special courts must have adequate qualifications, including experience in handling corporate law or financial crimes, and to have an in-depth understanding of the provisions of Companies Act. The appointment of such judge is made by the central government in consultation with the Chief Justice of India. Now, Special Court for Corporate Fraud under Section 435 speaks about specifically dealing with the fraud-related offenses under Companies Act. As mentioned earlier, these offenses can include financial manipulation, misrepresentation in financial statements, misleading shareholders or public. Such cases can have severe impact on investors, creditors, and overall economy, necessitating the fast legal proceedings. With this, we come to an end with Section 435, that is the establishment of special courts.
Ravi, why can't you give some focus upon the special courts thing? About the brief about background as well as the present scenario.
The 2-year threshold which is provided in the Section 435 is very interesting to understand. Punishable with imprisonment of 2 years or more. And therefore, a court of sessions judge or additional sessions judge can be the designated court or court of that rank will be set up or established in order to deal with offenses. Now, if you look at the notifications, for example, there was a notification on 17th July 2019 issued by the Government of India establishing a special court of the District Judge 1 and Additional Sessions Judge Pune as the jurisdiction court, special court for the purpose of trial of offences with imprisonment of 2 years or more. This was for the state of Maharashtra. At the same time, there was another notification issued on 28th August 2019, which was in relation to the state of Maharashtra. Whatever I said in this one is reduced to the whole state of Maharashtra except Pune, Ahmednagar, Kolhapur, Solapur, Satra, Sangli, Ratnagiri, Sindhugar districts, etc. Similarly, there was another notification of Maharashtra pertaining to Maharashtra in August 2019. So there is a difference between the special court of the jurisdiction in Pune and other parts and certain other parts, which this July 2019 and the August 2019 notifications will be able to help you to understand which is the jurisdiction court with respect to that. Second point which we need to remember is when we talk about establishment of special courts, particularly if you read 439, which the presenter has not yet gone, but I will tell you an important point here. No court shall take cognizance of an offence under this act which is alleged to have been committed by any company or officer thereof, except on the complaint in writing of the registrar or a shareholder or a member of the company or of a person authorized by central government in that behalf. So therefore, there is also something which we need to understand as who is authorized to filing the complaint before a court. So that is number 2. The number 3, which is important here is, which is about the courts having jurisdiction across every district. For example, the court of judicial magistrate, metropolitan magistrate. They are the proper courts for dealing with all the offences. But when it comes to 435 special court and the jurisdiction of a metropolitan magistrate or a judicial magistrate of the first class for offences less than 2 years, most of the cases which I have studied, you will find that pursuant to decriminalization, what does it mean? I think everyone is aware, but I'll like to 1 minute I'll explain that offences punishable with fine. Fine is a punishment which can be imposed on an accused provided he is proved guilty, and therefore it is a system coming under the criminal justice system by the CA. The procedures are controlled by the CRPC. The criminal courts will only be able to award a sentence of fine, not to speak about imprisonment. On the other hand, there are cases where, for example, under the Companies Act, or the securities laws, or the foreign exchange management law, any other, for example, economic laws, you will find the word penalty is used. In contradistinction with fine, we should be able to understand this. And when we saw 454 introduced into the Companies Act for adjudication of penalties, whole lot of provisions of the Companies Act was amended to prescribe a punishment mechanism in the form of monetary penalty and stop with that. So most of the technical offences or offences of a technical nature. So what happens is, penalty is introduced by the company law in order to deal with technical offences or offences of technical nature. Therefore, coming back to the point is, the decriminalization has mostly done away with the jurisdiction conferred upon on the metropolitan magistrate court or the chief judicial magistrate of the first class, because offences less than 2 years, mostly they are now removed from the scene, hardly there are any offenses. Another point I want to tell is whenever we deal with establishment of special courts and the further provisions, which in the beginning of the slide she has beautifully brought out in one slide all the provisions of the chapter 28. Remember always this chapter 28 must be complemented and understood in conjunction with chapter 14, which is inspection, inquiry, and investigation. Just half of 28 for you to remember that, right? This 212, 213, these provisions are intertwined with these provisions of chapter 28. And therefore, the most of the offenses which are tried in special courts, that is the courts of sessions judge and above, you will find that they are emanating from a complaint filed on account of an inspection report, maybe by the government of India through the 212 process, SFIO, or the 213 process, or the registrar's process commencing from 206. So I think that is the brief intro with respect to the I'm not going into class of offenses, section related offenses. Generally, I am saying special courts are already there. Different states, different districts, Government of India has already announced the special courts, designated special courts, existing courts designated as special courts. Training programs in Judicial Academy is happening across the states on what are the powers of special court, how to deal with economic offenses, and how to deal with cases falling under the Companies Act. That is important for us. But more efficient system is the special court trying offenses filed by SEBI. That special court is really very effective and efficient. Unlike this, because generally when a special court offense is prosecuted, the proceedings, the criminal justice system is set on motion. Immediately we run to the high courts, ask for 482 relief for quashing the offenses, despite Bhajan Lal decisions and whatnot. Normally we will go to the case of this thing. As we progress in the presentation, I will share some more thoughts. Thank you.
Thank you so much, sir. Moving ahead to section 436, that is offences triable by special courts. In this section, we understand that section 436 of the Companies Act being an important legal provision that empowers the central government to direct National Company Law Tribunal, that is NCLT, or National Company Law Appellate Tribunal, that is NCLAT, to take action in cases where a company has failed to comply with statutory obligations. The section ensures that the government can intervene when a company does not follow regulations related to financial disclosures, maintenance of books of accounts, or other important compliance issues. The objective behind the section was to ensure corporate accountability and regulatory compliance. The Companies Act seeks to enhance transparency in company operations, particularly in the context of financial reporting and compliance with legal obligations. Well, further certain sub-provisions are also there in section 436. The first one, section 436 subsection 1, speaks about the central government authority, where the central government has the power to direct NCLT or NCLAT to take action if a company fails to comply with the statutory requirements under Companies Act. The key focus under this is failure to file documents, wherein non-filing of annual returns or financial statements are involved. Any such non-compliances involved with government standards, then failure to maintain proper books of accounts, auditing records, or fraudulent reporting. The purpose behind this is to ensure that companies adhere to the legal and regulatory requirements. Moving further, under section 436, subsection 2, enforcement measures. It is enforced by certain penalties that can be imposed by NCLT or NCLAT on the company or any of the directors. The possible penalties includes fine, which can be monetary penalties for any non-compliance, suspension or revocation of licenses if the statutory requires the same, imposition of restrictions, where restrictions on company operations are there until compliance is achieved. It also speaks about directors' liability, wherein directors may also be personally held liable for any such non-compliance. 436 subsection 3 speaks about appointment of inspectors or auditors, when the NCLT or NCLAT can appoint inspectors or auditors in order to investigate the company records and ensure the compliance to the fullest. What are the enforcement powers here? The first one is investigation and order, where the tribunal can issue orders and conduct investigation to ensure the company's compliance with law. Delegation of powers. The central government may delegate its powers to the tribunal for such enforcement. Further, we read about the powers of the tribunal, that is NCLT or NCLAT. The NCLT or NCLAT plays a crucial role in the enforcement of Section 436. These tribunals are vested with significant powers to act against the non-compliant companies. The tribunal can appoint auditors or inspectors to carry out a comprehensive investigation of the company's records, including financial statements and other essential documents. If a company is found in violation, the tribunal has the authority to impose penalties, including fines, either on the company or on its directors, or any suspension or even cancellation of such business operation until the company complies with the order. The tribunal also has the power to disqualify directors of the company from holding directorships in other companies if such non-compliance is due to negligence or fraud in their part. The tribunal may also issue specific directions to the company to take corrective actions, such as filing overdue documents, paying penalties, or rectifying internal governance lapse. So I would like to ask you if you could speak a little more about the disqualification of the directors or how such order can impact upon the directors.
I'd like to say a few words on Section 436. The structure of these provisions is in such a way that firstly, 435 designates the courts which is a trial court. Very important for us to understand 435 is to say which court is empowered to try offences under the Companies Act. And the division of power is basis the imprisonment level of 2 years or more in cases and less than 2 years. So this is how it is to be done insofar as 435 is concerned. In order to understand chapter 28, we have to thoroughly understand 435 is for designating which is the court to try the offences under the Companies Act. Number one is that. Number two is in respect of offences triable by special courts. What will be the scenario with respect to certain aspects? For example, how they will try this. If you take 436, 436 talks about notwithstanding anything contained in the Code of Criminal Procedure. That is number one. All offences shall be triable only by the special court. That only is very important. Only by the special court designated for the area in which the registered office in relation to which the offence is committed. So a director could come from Kashmir, a director may be from Kanyakumari, doesn't matter. Where the registered office is situated, this is the registered office only. So see, understand this 436 and its beauty. Number one, notwithstanding anything contained in the Code of Criminal Procedure. Sweeping, which means there could be a prosecution could club a provision of criminal IPC or some other law and bring it alongside 447 or some other provision of the Companies Act, and therefore the jurisdiction is important. That is why they say notwithstanding anything contained in CRPC, it is a special courts designated under 435 for the respective area. Only that special court can try the offences under the Companies Act. Number one, where situate in the registered office of the company. Therefore, whenever we talk about companies being prosecuted, remember the jurisdiction is with that special court. That is why I took you in the beginning itself about the notification of 2019 July August, particularly for the state of Maharashtra. Therefore, remember, registered office is very important. Incidentally, we should also understand 436(1) itself with this understanding that see the beauty of the definition for various people whom you really remove this slide. I don't want these slides. This is wrong. 436 is not what you have presented. You have presented some other provision. That is why I am taking an effort to explain it. The special court with the jurisdiction to try offences under the Companies Act. Therefore, officers may be elsewhere. Company may be functioning in several jurisdictions across the country, outside the country. Therefore, this is important. This gives you a sort of, please see the ease of doing business for a corporate. We can understand whole lot of things from a single provision. Please see the ease of doing business of a corporate. That offense, if any, the corporate's registered office will decide the whole thing. Officers may be co-accused, that also will decide. Let us also go into another beauty of this provision. See, legislature has beautifully added the sentence in which the registered office of the company in relation to which the offense is committed. Therefore, company is the first accused. Please understand the beauty of it. There cannot be a case of offense under the Companies Act, punishable with some imprisonment of 2 years and more or less than that, and company is not a party or accused. So please remember one provision, how many things we can understand. 436, 1 clause A. That's all I have said so far. Now let us go to the clause B. Any person includes company or natural person, but for clause B, any person accused of or suspected of commission of an offence under the Companies Act is forwarded to the magistrate, and such magistrate may authorize detention of such person. That is why I said a person may include company or individual, but for clause B, it talks about detention of such person in such custody as he thinks fit for a period not exceeding 15 days in the whole, which means sometimes it can be extended up to 7 days first, then another 7 days next. So therefore, clause B is pertaining to only natural persons. Now let us go to the proviso. Before the expiry of the period, if the magistrate considers detention of such person is unnecessary. For example, somebody is detained. That person finds he can go to the magistrate. Magistrate is empowered to release. That is another important point. He shall order such person to be forwarded to the special court having jurisdiction. The special court may exercise in relation to the person forwarded to the special court by the magistrate to try a case in relation to an accused person forwarded under that section. So again, what happens from magistrate? It goes to the special court. Then upon perusal of the police report or upon perusal of the complaint, the special court may take cognizance of the offence without the accused being committed for trial. We have to use this provision. When such prosecution takes place, it is against some officer, some CFO, company secretary, or somebody is wantonly added, some auditor is added, some company secretary practice is added. We should be able to understand these line by line, word by word, and make this magistrate forward it to special court. Special court may try the offence without the accused being committed to it for trial. This is what requires education at the Judicial Academy to the officers who are sitting as the court judges. Then comes your clause number, subsection 2. In 436, subsection 2 is another very interesting provision. When trying an offence, the special court may also try. Please see the 1 and 2. 1, I was telling you, in relation to the offences under the Companies Act. Then I was also giving you an idea that there could be some other offences which are IPC offences or some other offences clubbed along with 447 or some other provision of the Companies Act. For that purpose, see the wisdom of the legislature, subsection 2. Subsection 2 says the special court may also try an offence other than an offence under this act with which the accused may be charged at the same trial. Please see the beautiful empowerment of the special court. The special court, which shall try the offences under the Companies Act, has also been empowered to try offences which are also other offences in accordance. Therefore, the jurisdiction is beautifully encompassing other offences so that the corporate and its officers added as accused need not run from pillar to post. This 436 can never be understood ordinarily. This is something which is very, very boon to the corporate way of doing business. Many people would not have understood it in this fashion, but this is the real truth of it. Then comes your another beautiful provision again. Normal criminal justice system. Why are we afraid of going through the trial process? Why are we saying it is always draconian? More than the punishment, more than the 1 year, 2 year, 5 year, 7 year, whatever be the punishment, the accused is always afraid of the trial process itself. It is a tedious process of going. He must be a managing director, chairperson, company secretary, stalwart, but he has to go to the ordinary court and stand there. That itself is a bigger punishment than anything else. Beautifully, 436.3 says, notwithstanding anything contained in the Code of Criminal Procedure, the special court may, if it thinks fit, try in a summary way. So because most of our corporates matters are matters of record. Records will speak. Therefore, what else can you speak when a record is produced? Minutes of the meeting is produced. What else can you produce? Your presence is recorded. Your attendance is there. Your decision is recorded there. So therefore, very less opportunity for a lengthy trial. Therefore, 436, class number subsection 3, very beautifully introduced as trying of offences in a summary way. Proviso. Provided in the case of any conviction, please understand the last point. In the case of conviction, in summary way, there shall be no sentence of imprisonment for a term exceeding 1 year shall be passed. Provided further, at the commencement or etc., this is something for saving thing. So I would like to stop here explaining 436 in relation to this. This tribunal, whatever you brought, you can remove it. This has got nothing to do with special court and 436. Alongside 436, we have to also remember two more provisions. I will take that, if you permit, now itself, so that connect is there, continuation is there.
Yeah, please go ahead. Please go ahead. And before that, I just wanted to get one thing clarified. Unless in the criminal procedure code, wherever the cases are filed, even though the cases are filed where the register office of the company is situated, in fact, people used to get the cases on certain matters to get it transferred to their place where they have been residing it. I think according to you, that is not possible in this particular case. The company law cases will be tried only at the place where the register office of the company is situated. There is no possibility of getting the cases transferred just because the director is actually residing somewhere else for his convenience, etc. Another thing and all. That is totally ruled out in this case. Am I correct?
Normally, we use 482 for only thinking about quashing the complaint itself. But inherent powers of courts can be used even for transfer of complaint to the proper jurisdiction. So therefore, Balakrishnan sir, whatever you said is perfectly correct. I wanted to highlight this point. Whenever any director, any officer is facing some harassment in this way, that person is able to apply this provision and attack the prosecution in the beginning itself. It's like a preliminary objection to this thing. So jurisdiction issue is a very important issue. Even under 482, it is possible to seek justice if you are being hauled up to run from pillar to post. Because sometimes, let us say, for example, I am the advisor, I am sitting in Coimbatore and I am advising a company in Guwahati. Somebody can say, from Coimbatore only I drafted the notice or something like that. They can bring a case against me in Coimbatore for a company sitting in Guwahati. What happens is, generally, also let us look at this very practically. The corporate will have the muscle power, manpower, money power to support the system. Individually, you don't need to run from pillar to post. You are not required to. If the corporate registered office is the place of jurisdiction for trial of offences, for all the accused in relation to a company where offence is committed, company will take care. Am I clear?
Yeah.
I will also read along with 435, 436, two more provisions. One is the 438. This 438 talks about to what extent the CRPC is applicable. The CRPC is applicable as far as the procedural law is concerned. It is CRPC, but summary or other the special court can decide. Then go to 439. Offences to be non-cognizable is a declaration of law. Offences to be non-cognizable except offences referred to in 212 subsection 6. 212, that is why I said chapter 28, you will be directed to chapter 14. 212 subsection 6, all provisions punishable with the offense of fraud under 447, you can read it. 212 subsection 6. So therefore, all offences are non-cognizable. That is very important. The other thing is, no court shall, 439 subsection 2. It's a very important provision. No court shall take cognizance of an offence. I have already said this in the beginning of itself. Unless the offence is filed by, unless the case is filed by on a complaint in writing by the registrar or a shareholder or a person authorized. Even there are cases where shareholder has filed a complaint under 447, the courts have rejected it. You come through 212 process. So that is 439. And in 439, we have two more provisions. Provided the court may take cognizance of offences relating to issue, transfer of securities, dividend, non-payment of dividend, on a complaint in writing by a person authorized by SEBI. So SEBI ke liye separate provision is there. Provided further, nothing in this section shall apply to prosecution by a company of its officer is a clarificatory provision. Suppose an officer is committing an offence against the company. It is an internal matter. An officer inside the company may commit some fraud, forgery and all. Company will be the victim. Company will be the complainant. So it is very categorically said under 439 that this provision does not apply for a company prosecuting against its officers committing a theft or murder or any other offense. That is the beauty of it. It is towards the company, against the company. An officer of the company is indulging in fraud, cheating, forgery or something like that. This provision need not be applicable. That you go under the CRPC and IPC or any other offense like Information Technology Act. So therefore, the second proviso under subsection 2 is very, very important, and it should be read in conjunction with the subsection 2, which says registrar, ROC, that is registrar of companies, shareholder or any person authorized by central government, or in relation to transfer, issue of securities, non-payment of dividend by SEBI, can only file complaint. That is not applicable to a offence committed by some officer, employee, staff of the company itself. Kindly remember this. Then another point is, where the complaint is filed by the registrar or any other person, please see the ease of doing business concept here. The presence of such officer shall not be necessary. Normally, when the court wants to take cognizance of an offence, the complainant must be present. He will be examined. What is his complaint? The magistrate will ask him. First question, what is his complaint? How do you say complaint is made out? The complainant has to come and testify before the court and tell that this is the complaint he is committed and all. So that is the process of taking cognizance of the offence will start with the examination of the complainant first. So that taking cognizance process, you don't suffer the ROC from Pune to travel all the way to some place. So therefore, the second part of 439 contained in subsection 3 is a very important provision which does not bother the officers unless the court requires his personal attendance. So I think we have covered sufficiently the important provisions contained in 435, 436 and 438 and 439. I will stop here again, come back to you as the presentation goes.
Thanks a lot, Ravi. There is already a question which is you already answered, because somebody raised the question if the office of the company commits the crime outside the company in the business matters and all, whether the special court has got a question. That is the question which has been asked. You are very nicely explained here. Thank you. Thanks a lot. Really, I think, you are working, what you call, expecting the anticipated questions. That is the way you are working, I think. Hats up to you. Yeah, go ahead.
Thank you, sir, for the beautiful insight. We will move ahead towards 437. Now, 437 deals with appeals and revision. So the overview of 437 is the section allows for appeal and revision from the decisions made by special courts under the Act. The High Court has the authority to exercise the powers conferred by the CRPC 1973, specifically under Chapter 20, 29 and 30. The key provisions of Section 437 deals with the High Court, that the High Court power of the High Court, which may exercise all powers granted under the CRPC of Chapters 29 and 30, as though the Special Court were a court of session. This means that the High Court can deal with appeals or revisions just as it would in criminal cases where a court of session has tried a case. Further, the scope of the application deals with appeals where a party may appeal a decision made by the Special Court, and in revision, the High Court has the power to revise the decision of the Special Court if there is an error or issue in the law or procedure. The role of the Special Court. A Special Court is treated as a court of session for the purpose of exercising appellate and revisional powers. The decision made by such Special Court can be appealed or revised by the High Court. The importance and implication of this section. It ensures legal recourse where individuals or entities who feel that the decision made by a special court under the Companies Act 2013 is unjust or incorrect, in alignment with the CRPC, by allowing the High Court to exercise powers under CRPC under Chapter 29 and 30, where the Act ensures that the process of appeal and revision follows established under a fair procedural rule and that used under criminal cases, ensuring consistency in legal practices. It provides an additional layer of judicial oversight, ensuring that decisions made by the lower court, that is the Special Court, can be scrutinized and corrected by a higher court, thus promoting fairness in judicial processes. It also leads to an efficient legal system, where the provision enhances the efficiency and effectiveness of legal system by providing a clear and structured approach to appeal and revision, especially in corporate matters that may involve complex issues. This is about Section 437, dealing with appeals and revision. So shall I move forward or?
Yeah. Please go ahead.
Okay.
You can move forward because I went up to 439.
Yes. So as sir has already explained 438, I will just give an overview of it. So 438 deals with the application of CRPC to the proceedings before a special court. A special court is designated for trying the cases related to offences under the Companies Act, particularly those of corporate fraud, financial crimes and violations. The object behind this was to ensure that the proceedings before the special court are governed by the provisions of CRPC, where applicable, to maintain consistency and fairness during the trial process. The application relates to the provisions of CRPC relating to the trial procedure applied to special courts conducting trials of offences under Companies Act 2013. These provisions are applicable and include the procedural framework for trial, the handling of evidence and conduct of witnesses, and filing of charges, amongst other criminal trial procedures. Now, what is the exclusion of an incapable provision in this? Not all provisions of the CRPC apply. Only those that are relevant to the specific nature of corporate offense trials are applied. For example, provisions related to pre-trial investigation, any warrant and arrest may not be directly applicable, but can be adjusted to fit to the corporate context. Ensuring consistency in legal process, the application of CRPC to proceedings before special court ensures that the process is consistent with established criminal law procedures, providing a fair and structured trial. Efficient trial for corporate cases. By applying CRPC, Section 438 helps to streamline the trial process for corporate offences, making it easier to manage complex financial crimes and corporate fraud cases. In terms of the certain legality and transparency, this provision enhances legal certainty by applying familiar criminal law rules to corporate-related offences, allowing greater transparency and accountability in corporate judicial proceedings. Further, moving to Section 439, offences to be non-cognizable. Overview of the section classifies certain corporate offences as non-cognizable. Non-cognizable offences are those where a police officer does not have the authority to arrest the accused without a warrant or initiate an investigation without the permission of a magistrate. The objective behind the section is to aim to reduce the severity of penalties and provide relief in case involving minor corporate violations that do not pose a serious threat to public safety or order. It emphasizes procedural fairness by ensuring that less severe offences are handled without immediate arrest or any police investigation. The key provisions are further explained as nature of the offences, where non-cognizable offences are less severe in terms of corporate violations, such as administrative or regulatory failure, where the impact is not substantial enough to require immediate police intervention. An example of such could be minor filing requirements or non-compliance with certain procedural aspect of the Companies Act. The implication which follows through is no immediate arrest. For non-cognizable offense, the police cannot arrest the accused without a warrant. This limits the scope of direct enforceability by the force. Investigation requirement. The police cannot initiate an investigation without prior permission from a magistrate. This ensures that the law enforcement can only pursue these cases after judicial review. What is the procedure of these non-cognizable offences? The first one is filing of a complaint. In case of a non-cognizable offence, a complaint is filed with the police or a magistrate. The police, upon receiving the complaint, must inform the complainant that they cannot proceed with an investigation without permission from a magistrate. The role of the magistrate involves a magistrate will review the nature of the offence and decide whether to allow an investigation. If the magistrate permits, the police can then initiate an investigation as they allow in any other case. Otherwise, the case may proceed based on the civil remedies or any other action. The arrest procedure involves, in case of a non-cognizable offence, arrest is not permitted without a warrant from the magistrate. The person accused of the offence cannot be arrested immediately by the police. The matter may be taken to the court for further proceedings, which could include hearings, filing of charges, and a trial if necessary. Since the offence is non-cognizable, the procedure is more formal and controlled through legal channels rather than any police intervention. So this was all about Section 439. So do you want to speak about it, or can I move ahead?
Yes, already explained 430. Up to 439 he has explained. Yeah, you can go ahead.
All right, sir. Now coming to Section 440, that deals about the transactional provisions for offences under the Act. Offences triable by a special court will be tried by a court of session, that is the metropolitan magistrate, where imprisonment is above 2 years, or judicial magistrate of first class, where imprisonment is up to 2 years based on the jurisdiction, until the special court is established, as it was already mentioned by Sir before. Exception under this is that this does not affect the High Court authority under Section 407 of the CRPC, which allows the transfer of cases from such lower courts. Moving ahead, Section 441 for compounding of offences. So let us first understand the concept of fines and penalties. Under penalties, an authority like an ROC or RD can impose penalties for non-compliance under the relevant provisions of Companies Act 2013. Penalties are used to indicate civil offences. So an application is made to the ROC or the RD where amount is less than 25 lakhs, or to NCLT where the amount is more than 25 lakhs. Penalties can be compounded in certain cases depending on the seriousness of the matter. Such a notification was passed, marking an important shift in the compounding offences under the Companies Act 2013, allowing penalties to be compounded for specific types of corporate offences, making it easier for companies to resolve compliance issues effectively. Fines. A court of law like NCLT or High Court can impose fines for criminal offences. Compounding of fines are done in case of compoundable offences, and only where fine is imposed, wherein if the word imprisonment or fine or imprisonment only is used, then the matter is classified as non-compoundable and further proceedings are conducted by special courts. Moving forward, objective of 441 allows the compounding, that is settling of certain offences committed under Companies Act 2013 without undergoing any formal prosecution. This process involves payment of a fine instead of pursuing any criminal action. Now, what are the eligible offences? The offence must not involve imprisonment or be punishable with imprisonment and fine. The tribunal or for fines below 25 lakhs, the RD or an officer authorized by central government can only approve compounding. The conditions for compounding further involve that the offence can be compounded before or after prosecution. The amount payable for compounding cannot exceed the maximum fine for the offence. If there is an investigation that is underway, compounding is not allowed in that. In terms of time limitations, compounding is not allowed for a second offence within 3 years from the previous compounded offence.
Yeah, when you say the second offence means under the Companies Act or under the particular section or the similar nature, what is it? Because here, if you say, once I done the compounding, I cannot do the compounding in the next 3 years at all. Is that the situation? Ravi, your view, please, on this.
The definition of the offense must match, sir. Previously, in the beginning, I was telling about what is the nature of offense and how ingredients are met. So we will call it as definition of the offense. So if there is an offense which is the same definition, it is committed once again within 3 years, then the problem of second offense comes. Second offense is stated as an offense committed within 3 years. And if you, previous slide, this is the slide. So if you go to the section 441, here it is talking about
my screen.
An offense shall not be compounded within a period of 3 years from the date on which a similar offense committed was compounded under this section. From the date on which a similar offense committed by it was compounded. So, if a person is a habitual offender, there is a problem under this provision. But it should be the same offense. It cannot be something different from what was previously compounded. You can go next.
Yes, sir. Thank you so much. Further is the procedure and the provisions under Section 441 for compounding of offences. Application process. An application is made to the registrar, where the company or its officers must apply to the registrar, who forwards it to the appropriate authority, being either the tribunal or the RD. Intimation. After compounding, the company must inform the registrar within a period of 7 days. Effect of compounding can be further explained as if it is compounded before prosecution, then no prosecution can be initiated. But if the compounding is done after prosecution, the court is notified for the same and the company or officer is discharged from such case. Certain further additional provisions which involve failure to comply, where the officer who fails to comply with an order may face a fine double than the usual amount for such offence. Non-compounding offences punishable by imprisonment or imprisonment and fine are such that are not compoundable. Section 442 that deals with mediation.
Sorry for interruption. Before we move to the other provisions, confining to compounding of offences, let us understand clearly that compounding is not a special provision only under the Companies Act. Compounding is there in the CRPC itself. Similarly, you take our Foreign Exchange Management Act or SEBI Act, Securities Contracts Regulation Act, Depositories Act. Compounding is a general way of providing relief because in compounding particularly we don't contest the commission of offense. While we may be praying for mitigating factors, we may supply or furnish and ask for levy of less compounding fee. Though it is called fine, it is not the legal language. Fine is, as I in the beginning mentioned, awarded by a sentence of punishment by the court, pronounced by the criminal court. So when you go to the compounding authority, whether regional director or the national law, company law tribunal, first question you will get is where to apply. Whether I should go to the registrar of companies or NCLT or RD, these provisions always have a difficulty. Therefore, the lawmaker has brought out an idea of monetary threshold and says up to this, we can call it as a pecuniary jurisdiction. It is peculiar to compounding provision, so pecuniary jurisdiction will keep it. 25 lakhs and above. So, but NCLAT, while dishing out a very elaborate judgment on the subject of 441, in the case of Ahuja Takai, several questions were answered by NCLAT in that decision with respect to compounding. Certain questions were whether a company and its officers could file only one application because after all the offense is same, accused may be different, persons likely to be accused or persons likely to be added as accused. So officer in default, whoever is coming under the category as per the penal clause. All that matters is the penal clause in the statute for the relevant offense. For example, you would have read about section 42, correct? Section 42, private placement of securities. There they talk about promoters and all. The punishment of penalty can be levied under 42 on promoter. There are other cases where, for example, you take 128, 129 like books of account. You will find that the managing director is liable or a person charged with the responsibility of complying with the provision is liable. There are other cases where it is said as all directors. There are other cases where the punishment clause provides generally officer in default, company and its officer in default. So basis that application for compounding can be made with the regional director through the ROC or with the NCLT, where also the report of the registrar will be asked. Another question NCLAT answered is, you can club one application company and other people. Another question which is asked by the answered by NCLAT was, even for less than 25 lakhs, NCLT is not having no power. We cannot say NCLT has no power. It is not possible because 25 lakhs and above itself is possible. Less than that also is possible. So there is no hard and fast rule as regards this, though it is specifically said regional director is the competent compounding authority for offences punishable with fine less than 25 lakhs. That is number 2. Number 3 is the brilliant or the illuminating provision. Once you file an application for compounding, the process of prosecution cannot be initiated. If it has already been initiated, cannot be continued. Number 3 is, if you know, yes, there is an offense. I can say number 4, if you know that an offense has been committed, mostly technical offenses, it is always better to apply before the prosecution is launched. When you receive the show cause notice itself, you can do, or voluntarily you can file application. This will remove lot of issues and you will also be able to get good relief. The other important point is about the second offense related matter. You cannot be doing the same offense again and try to avail the benefit of the less severe compounding under 441. Compounding was a tough subject. We had several companies going to the court. I remember the case of Reliance Industries was a Section 84 Companies Act 1956 case, where there was a share switching issue, but Reliance brilliantly applied under the erstwhile 621A to get this offense compounded. And in long before, I am saying, maybe 15 years before, even the company secretary had paid a compounding fee of about 5 lakh rupees. At the same time, there was a company called Rashtriya Sugars in Coimbatore, where the issue was about 100 shares. The certificate for the 100 shares not issued. So the shareholder has filed a complaint with the ROC. The ROC went to the Chief Judicial Magistrate Coimbatore, and the question was whether ROC is a competent person filing complaint in relation to a non-receipt of share certificate by a shareholder. The company for this 100 shares certificate case, when ROC filed the complaint here, they could have gone for compounding, they could have delivered the certificate. Instead of that, they went to High Court, then went to Supreme Court. Ultimately, Supreme Court has to answer, yes, under the Companies Act, ROC is the proper person for filing complaint, he is the prosecution in charge. The shareholder is maybe empowered, but doesn't mean the shareholder should only file the complaint. The ROC is meant for taking care of investors' protection and all. ROC is the right person as per the provision. Therefore, they spent lakhs and lakhs in several unnecessary proceedings to get a ruling from the Supreme Court that ROC is a competent person, like what I read in 439(2). So therefore, compounding is a wonderful provision when your company's offenses are such, they are proved by records, and records are clear, you will be benefited by filing under 441 and putting an end. See, businessman has to function in a business-like manner. That is why this provision is introduced. Non-compoundable offenses, the fifth item in my 441 is offenses punishable with imprisonment only, or where imprisonment is compulsory. It is there, compounding is not possible. That's all. Now you can move to the next.
Thank you so much, sir. Moving ahead over the other sections, that is 442, dealing with mediation and conciliation panel. Panel formation. The central government maintains a mediation and conciliation panel consisting of experts with prescribed qualification. The panel is meant to mediate between parties during proceedings before the central government tribunal or appellate tribunal under the Companies Act. The application for such mediation, wherein the party in a proceeding can apply to the central government or the tribunal or the appellate tribunal to refer to the matter to the panel. The application must be submitted within the prescribed form and fee. The certain authority will then appoint one or more experts from the panel. Procedure and recommendation. It is a suo motu referral where the central government, tribunal, or the appellate tribunal can also refer matters to the panel in their own during ongoing proceedings. Any expert fees or terms wherein the fees and the terms of experts are prescribed by the relevant authorities. The panel must resolve the matter within a period of 3 months and also provide recommendations to the concerned authority. The object behind this is that any party dissatisfied with the panel's recommendation can file objections with the central government or the tribunal or the appellate tribunal. So shall I move ahead to the next section?
Yeah.
All right.
I want to add one point here. 442, that is mediation, is a misfit in chapter 28. It should come under chapter 27. It has got nothing to do with offenses and prosecution. It is about tribunal matters, for example, litigations like operational mismanagement cases. There, 442 will have to be there. So it is not a chapter 28 matter, though it is coming under chapter 28. Thank you.
Further, section 443 that deals with the power of the central government to appoint company prosecutors. Here, the central government has the authority to appoint company prosecutors for conducting prosecutions under the Companies Act. The appointment can be made generally for specific cases or for specified classes of cases in the designated local area. Following which, the powers and the privileges where the company prosecutors appointed under this provision are granted the same power and privileges as public prosecutors appointed under Section 24 of CRPC. This section empowers the central government to designate company prosecutors with the authority to handle legal matters arising under the Companies Act. So shall I move to the next section?
Yeah.
All right. Section 444, appeal against acquittal. The central government has the authority to direct a company prosecutor or authorize another person to present an appeal against an order of acquittal passed by any court except that of High Court. And the appeal presented by the appointed prosecutor or authorized person will be considered validly present to the appellate court, regardless of the provisions of CRBC. This provision allows the central government to ensure that appeals from acquittal in certain cases under the Companies Act are properly pursued. Section 445 speaks about compensation for acquisition without reasonable cause. The provision of Section 250 of the CRPC shall apply mutatis mutandis to compensation for acquisition without reasonable cause before the special court or the court of session. Further, Section 446, which speaks about application of fines. The court imposing any fine under this Act may direct that the whole or any part thereof which shall be applied in or towards payment of the cost of proceedings or in or towards the payment of a reward to the person on whose information the proceedings were instituted. 446 is further divided into Section 446A and 446B, wherein 446 deals with the factors for determining the level of such punishment. The court or the special court, while deciding the amount of fine or imprisonment under this Act, shall have due regard to the following factors. Such factors namely include the size of the company, nature of the business carried on by the company, the injury that is caused to the public interest, nature of the default, and such repetition of the default. Further, Section 446B deals with lesser penalties for OPC one-person companies or small companies. Penalty for non-compliance by certain companies involve reduced penalty for specific companies, wherein if an OPC or a small company or a startup company, producer company, fail to comply with the provisions of the Companies Act, the penalty will be half of the specified penalty, subject to a maximum of rupees 2 lakhs for the company and maximum of rupees 1 lakh for an officer or any other person in default. Over here, producer company is particularly defined under Section 378A of the Act, whereas a startup company is a private company recognized as a startup by the central government under the Department for Promotion of Industry and Internal Trade. This provision aims to reduce the financial burden of penalties for smaller companies in case of deciding for such non-compliances. Yes, sir. That is towards the end of the presentation.
Okay, we will take up the questions what is appearing in the chat box.
Yeah, Mr. Balakrishnan.
Yeah.
Before we go into the questions and all,
yeah,
I will give you some small intro into certain important things to add some value to this program.
Yes, please, go ahead.
It is always necessary to understand the provisions of 2126 connected with 447 for appreciating the various powers conferred upon the courts and the jurisdiction thereto. For example, under 2126, you will be finding a draconian provision which says that the court cannot grant bail unless, the language is like this, unless the public prosecutor, which you have read now only, the court under section 24 of the CRPC, government has power to appoint company prosecutors. They have the power similar to public prosecutors. You read that. The public prosecutor has been given an opportunity to oppose the application for such release, that is release on bail, for all the offences punishable under 447. Under 2126, we should read it, 28 to 14. Where the public prosecutor is opposing the application, naturally every case he will oppose. The court is satisfied that the reasonable grounds, please read the language is very important. There are reasonable grounds for believing, that is court has to believe, that the accused is not guilty of such offense and he is not likely to commence any offense, he is not likely to commit any offense while on bail. 1. In order to apply for bail under 2126, when a prosecution is filed only by the Serious Fraud Investigation Office or an officer of the central government, nobody else can do it. for 447. 439 2 I read. Only shareholder also can file complaint. But the exception is 2126 clearly says special court shall not take cognizance of any offence under this section, that is read with 447, unless the complaint is filed by SFIO director or a person or officer authorized by the central government. Therefore, ordinary shareholder cannot file a complaint. This is one. Two, when such a complaint is filed and you are added as an accused, will you be able to get bail so easily? Is what is written in 2126. It is like your PMLA, Narcotics Substance Act, and draconian law like the Prevention of Terrorism, POTA, and something like that. Is there? No, it is like that. Public prosecutor should be given notice. If the public prosecutor opposes, the court cannot grant bail unless the court feels, it believes that the accused may not be guilty. How will the court believe so easily, immediately in the beginning? It has to understand the whole material on record. Unless the court believes the accused is not likely to be held guilty and accused will not commit the offense during on bail. So section 2126 is a very seriously contested section. Several proceedings before Delhi High Court, some other high courts and Supreme Court is there. There are several case law. In my book on offences prosecution, I have handled this matter quite elaborately on bail under section 2126 itself, covering 45 of PMLA and NDPS, that is narcotics, some psychotropic or something like that, Substances Act. Okay, anyway, we don't look at it, so we don't learn about that. Okay, that is one point. Second point is increasingly you would have seen, because she has presented about some powers of tribunal also, in slide, though inadvertently, but I will connect the relevance of that. There are increasingly oppression management cases, mismanagement cases where fabrication, fraud, forgery, everything is added. Generally, the pleadings are usual. The respondent number 1 or 2, who is the managing director of the company, has committed fraud, forgery, fabricated documents, filed a lot of misstatements before the registrar of companies, something like that. Mostly the shares will be robbed, somebody's shares will be removed, somebody's directorship will be removed, some other document will be created to give control, all these things. So increasingly, in oppression mismanagement cases, under 241, 242, when it is filed before NCLT, they will always add a prosecution under 447 as though tribunal has any power, as though shareholder has any power to ask for it. So in this regard, you may note NCLT in Dulichand Motors Private Limited and others in a company petition under 241, 242, NCLT, I think Kolkata bench, they found a petition filed under 241, initiation of proceedings under 447 and 448. This is not NCLT's job, but the prayer includes it. The learned counsel to the petitioner claimed petition number 1 was the director of the company since 2023. He was illegally removed from directorship. This is what I am saying. Basis digital signature of the petition number 1. This is what is happening in small companies, but these are all the complaints they normally file, and there is a forgery, cheating, all those things done by all the respondents, and the petitioner is the person who has filed such a thing. The findings are, the NCLT says, the case in hand is about forgery and fraud, claimed to have been committed by respondents, fraudulently removing petitioners with forged documents. Digital signature of the petitioner is used. Fraudulently transferring his entire shareholding with the forged initials of the petitioner in favor of respondents. Illegally appointing somebody as a director. Obtaining loans by fraudulently issuing petitioners as guarantors. See, kind of allegations in the company petition. Of course, the NCLT went into all these things. There are matters pertaining to investigation. They have to go for investigation. At this point of time, the NCLT says, suffice it to say that we will give the following relief. So therefore, please understand, increasingly, 447, 448 are used through 241. So neither the provision comes in chapter 28. 29 is 447, correct? So all these things we are, combined at the whole of provisions have to be understood. There are several other decisions with respect to shareholders filing complaints, jurisdictions, quashing of criminal complaint, relief under another provision called 463. Maybe in some other occasion we will take care of those things maybe in some more detail. Thank you very much.
Ravi, when you are filing a quashing of the petition under section 482, I think I also seen a couple of cases. What happens is, by and large, the quashing does not happen actually. Because by and large, what happens is they say, okay, what we do is we will actually revert the case back to the trial court. During the course of trial procedure on the merit, the case can be decided. Otherwise, quashing cannot be done. That is what it is there. So what is your view? How do you actually get the quashing if you want to get the quashing done at all?
See, this is 482 quashing of criminal complaint as against a particular accused depends on the facts and circumstances of the case. One of the queries in the chat box is in relation to adjudication of penalties. But most of the time, prosecution, what happens is, even if you take a criminal complaint under 138 of the Negotiable Instruments Act, criminal complaint always is issued against all the directors. Though it is very clear company can be the accused, person in charge and responsible for the management of the affairs could be accused, the person who has signed the check could be the accused, not all the directors. But the lawyers representing the complainant side will always add everybody in the field, all directors accused. So there is a possibility for getting it quashed. Another thing, for example, somebody would have committed the crime, her husband or somebody would have done it, and simply the available persons are added as accused. That is another thing. The other thing is, I have entered as a director only in 23. Offense was committed in 2017. Yet my name is added. I can get it quashed. Yet another illustrating, very important illustration I will give you. Karnataka High Court, I handled this matter. The SFIO, that is under 212. SFIO adds a chartered accountant in practice as an accused with an averment in the complaint saying the company was acting according to his instructions, therefore he is deemed to be a director. Please see this. You are an advisor, you are a consultant, you are giving some solution to some problems company is facing, or you are giving some strategic guidance. Doesn't mean the whole board is acting according to your instructions. SFIO, not ordinary complainant. Department files a complaint, auditor is added based on some mail correspondence between company and the auditor. Therefore,
moreover, under the new act, the definition of director is entirely different. There is no shadow director concept at all in the new act.
That is what I was answering Mr. Balakrishnan's question. In what circumstances would High Court under 482 will quash? There are circumstances in which only it can do, not in every circumstance. I am fully in agreement with you, sir. Thank you, sir.
Yeah, we'll take up the questions whatever is there in the chat box. The first question which is actually coming, when the ROC issues the notice calling for the adjudication for the default, there's a limitation of the time apply. For example, if the director report for the year ended 31/3/2019 and information is actually missed out. Now on the current date, ROC finds the default and issue notices for the adjudication. Whether ROC can do so, whether the action correct, keeping in time line in the consideration.
For all the proceedings, compounding, adjudication, prosecution, civil proceedings, limitation will apply.
No, but here he is saying some information in year 2019, can he take action? But ROC has actually initiated actions relating to various matters even right from 2006 onwards. Because I have seen default committed about 10 years back also has been taken and they have passed an adjudication order.
Yes, sir. This is usual. I have received recently a query from a client. ROC is asking all the information, books of account records for 15 years.
Yeah.
Simply they are asking. You give 15 years. Minutes, books, attendance, registers, books, accounts. Forget about secretarial standard and preservation of records and the period for which it has to be maintained. See, that is why I am saying when these things are done by officers, we have a concern. How can officers do when they know it is not valid, when they know it is not necessary? Still, they do it. That is why in the beginning itself I told you it is a tendency of the prosecution A to elaborate, exaggerate, B to add everyone. This is I told you in the beginning itself. In adjudication also the same.
It has been actually happening. In fact, various adjudication orders I have seen, it runs through beyond 8 years, 9 years of the limit, the period of preservation. It goes even 10 years.
Sir, you take practically. I always follow this Reliance example. Take practically. What is the easiest way of closing the file? Do that. Can you think of going and engaging a lawyer, high court, quash, writ petition? Why do you do all this adjudication of penalty? ठीक है, जाने दो 1 lakh, 2 lakh, दे दो बस खत्म काम. Come out. So the matter is getting closed. That is why people do not contest it.
So that means cost versus getting the relief.
Yeah, I gave you an example of Rashi Sugas upfront. To answer this question, only gave you in advance itself. Did they not go to Chief Judicial Magistrate, to High Court, to Supreme Court and come back after 10 years to again the same CJM court? How much they would have spent, whatever the time is lost. So we need to understand, though limitation applies, getting it done through the ROC process is not possible. ROC will not relent.
Companies Act provides penal provision by way of the fine and penalty for violation of the Companies Act. Imposing the fines and penalty, officers in default is the jurisdiction they are acting on behalf of the
I will
company.
answer this.
Yeah.
See, Mr. Vinay or somebody has asked this question. I read it during the presentation itself. Company is, this is basically arising from the flaw in understanding. One, company is the artificial person, agree. That means company does everything. So when you are able to imaginarily believe company is the artificial person for the purpose of running its business, you should also believe imaginarily company is liable to be punished. Number one. Number two, all acts of officers, directors, agents are identified and understood as acts of the company. Please understand this principle called identification principle of attributing. 2. 3. Directors and officers are not liable. They are acting for the company. It is the ulta of what the queryist has asked. They are liable provided vicariously. Penal clause provides director, officer, and default is also liable. 3 things I have told you. 1. Imaginarily you believe company is a person, legal person, artificial person. It is capable of doing everything, capable of suing, owning, etc. It is also capable of being punished. Number 2, all acts of directors, officers, agents are identified as that of the company itself. Number 2. Number 3, directors, officers are not liable. They are vicariously liable provided the language of the penal clause statute requires it to be done. Imagine Bhopal gas tragedy. If your officer is liable, would you be getting crores and crores of rupees as compensation awarded on the officer and collecting it? Impossible. So this is actually a philosophical thought which I am sharing. Thank you.
If all the adjudication matters, almost all the cases we see that every director is actually penalized. When we read the section 260, officer whose default, it goes in this order. Full-time director, KMP, where there is no KMP, then such director or director as specified in the board, etc. Every director who is actually aware of the contravention. Where a company has a WTD or KMP, we the ROC and RD go up to identify the officer in default and penalize every director where the officer in default is actually defined in the section itself.
You have to argue this matter before the adjudicating. I have argued and they have removed the names of people who are not liable as per the penal clause.
You are absolutely right. I also done that. In fact, they added all the independent director as well. And after argument, those names were actually dropped. That is true. What you are saying is I 100% agree with you.
That is why I am reiterating when director of SFIO, central government officer, authorized person, ROC, they should not do it. That's problem is, why would they include first of all those people? That is the problem, even though they are the officers of the government.
What is the timeline for filing the special court order with the MCA from INC 28? Is it 30 days from the date of the receipt of the copy of the order, or it is 30 days from the date of the order? Kindly advise.
Sir, Sasikala case adjudication officer has failed to serve the copy of the notice for 13 years. Ultimately, they served the notice. After notice is served, only proceedings can commence. So she quashed all the proceedings, saying that I was not involved in the whole process. And ultimately, when she was imprisoned and she was in Karnataka jail, the notice was served by the prosecutor, that is Enforcement Directorate, after 13 years. So filing of form is the last other thing we are discussing. When an order is pronounced, it has become final, it has attained finality. File it within 30 days, that's all. If there is no provision also, you file it.
I think the next question you already answered. The activity done by the certain employee outside the company that you have explained actually. Yeah. Can a member file a case against the special court? That also I think you answered actually.
Yes, sir. Yes, sir. Read it 447, read with 2126. If you want
case of
also, I can give you. Most important case law is Nikanti Venkatrao versus Jaka Vinod Kumar Reddy, 2022. Is a very important case. Gopal versus Sri Ganga Reddy is another important case. There is also a case called Vikas Agarwal versus SFIO. There is another interesting case on the aspect of auditors. Union of India versus Deloitte Haskins and Sells. It went up to Supreme Court. So because auditor has resigned, auditor is punished. Why would you unnecessarily prosecute him under 447? The Supreme Court said they are all separate proceedings and separate punishments. You cannot escape. Right, sir?
In case of the offences under Companies Act 2013, where the penalty provisions are actually provided, not fines, can the company move the compounding application with the RD or more only adjudication application with the ROC for adjudicating with the ROC and then appeal to the RD if need be?
You are correct, sir. 454 only will apply, not 441.
If employee is actually involved in that I think you have already answered that. Bail has to be applied with the individually signing in the bail application, right? Bail comes only after arrested or correct, or before the arrest, anybody can claim anyone in the bail right. I think anticipatory bail is available, right? Yeah. Sorry, any update on section 463, power of the court to grant relief?
I have already said you need to find out, sit in the boardroom, identify what is the side you are standing. If your material evidence, if your records, the definition of offense, ingredients, you are not likely to escape, it is not compoundable, then you use 463, and 463 always comes with a caveat. You cannot go and argue there I didn't commit. Number one. Number two, you must be able to show that you have acted honestly and reasonably. Two ingredients high courts will always see. Two ingredients. Number three is 463 is of two parts, whether before prosecution is launched you are invoking 463 or after prosecution is launched. So which court is empowered or granting relief under 463 depends on that. Though Justice V. Ramasubramaniam, now retired Supreme Court judge, in Visram Finance case, has clarified that High Court has power to give relief even after prosecution is launched. The other point is 463 is not available to the companies, which is actually ditto of 633 of the 1956 Act. That's all about 463.
all the parties involved should be called for the investigation. Is that right? If they are not called for, then what is the case itself?
Beautiful question somebody has asked. I will ask somebody to read, I think 207 subsection 4 and also 217 subsection 6. You can read these two provisions. If you want, I will just show it to you. 217, I will read it because he has asked. If the director or officer of the company disobeys the direction issued by the registrar, inspector, etc., he shall be punishable with imprisonment which may extend to 1 year and with fine which shall not be less than 25,000 which may extend to 1 lakh rupee. If the director or officer is convicted of the offence of disobeying the officer director on and from the date of conviction, be deemed to have vacated his office as such, whatever office he was holding, and on such vacation of office, he shall be disqualified from holding an office, in any company. Right, sir?
What is the limitation period for the financial statement filed in the year 2011 and 12? I think limitation period we talked also, because what happens in the ROC level and all this, they go any amount of the year. Because the limitation
Depends on offense also. If it is a serious offense, you have come to know about it now only and all. So there could be a fraud. So limitation may get extended in relation to offense. Otherwise, if your non-filing is the question, that the question is answered differently. If the offense is arising from delay in filing or default in filing, the point is different. Normally, offense punishable with fine 6 months only.
Independent director were given immunity by the notification. No, independent director, although given a immunity, but if the decisions taken are consented to the board process, they cannot escape. Correct?
Independent directors enjoy the provision of exception in terms of treatment under the LODR also, as well as 149(12). Independent directors have got the protection under law. If you take 140 to 149 subsection 12 or your LODR, but if there is a consent or connivance, if you can prove through the board process that the independent director has consented to or has winked at it, connived, is liable.
Somebody is actually checking with you, Ravi, about your book. Sorry, your book is actually Guide to the Compounding Education Prosecution under Company Law, Security Laws and FEMA. Is that correct?
Yeah, this is the book.
I think this is the right book he has mentioned actually.
People don't buy it because it is very heavy.
Sir, your edition has come, 4th edition.
Yes, sir.
That is the thing. Your edition, which has actually now come, is the 4th edition.
Yeah, 5th edition is underway.
Oh, great.
Right.
If the company is actually violated section 42 or section 136, can a director apply for the relief under section 463?
Yes. We have applied for relief under 463 when this disqualification problem arose and DIN was blocked. So we used in Madras High Court. I was the first person to use 463 and get the DIN open. Thereafter, many people filed the applications.
Ravi, with a due respect, I just wanted to get a small understanding or clarification what I think. I'll ask you. You know, what happens is the Companies Amendment Act, which actually came decriminalizing and giving the adjudication power to the ROC under section 203, 5 and other sections, etc. and other thing and all. So effective from 2nd November 2018. That is the case. Now, when this has actually come, what happened to the cases which has been actually filed, the compounding cases under 441 earlier? Under 1956 Act, that is, if you are talking about the company's appointment, etc., section 383A, if you are talking about the 2013 Act, taken 2205, etc., and other thing and all, which has been filed before, say, 2nd November 2018. Now, I have actually seen wherever the prosecution cases has been filed and wherever the compounding application has been filed, many of the jurisdictions, they have actually transferred the cases saying that now that cases have been actually decriminalized, this all the thing decision authority falls under the jurisdiction of the ROC. And therefore, we are transferring the cases with a direction to the ROC to issue the adjudication notice and you follow the procedure. That is what I have seen in many cases. And it has actually happened like that also. But what happened, I recently came out, there are two issues I came out. One is actually in 2013, I came out a case where this has been actually done. But very recently in 2014, a Calcutta ROC has actually taken over the case. This case is very, very peculiar. Non-appointment of the company secretary and the CFO right from the year 2006 onwards till 2024. Now what he has done is he has actually taken up the case and he has issued the notices, etc. While passing the order, he bifurcated this order into two parts. That is starting from 2006 onwards up to 1st December 2018. And then he has taken from 2018 onwards till 21. And he said, I am leaving the penalty because according to me, that these offences can be penalized only effective from 2nd November 2018 when the Act has given the effect. Prior to that, he has actually directed the company. In fact, there are company and past director, current director, everybody is involved. I am directing you to file the necessary compounding application to the appropriate authority. This is what he has done. Now, what is your view actually on this? Because when this thing is come, is it not that everything has been actually decriminalized? Whatever the cases are filed, it can be tried and it can be done. Adjudication process can be done. Or is this correct? Because there are contrary things which I have seen 1 year back and now. It is a very recent case which has actually happened on, I think, 27th November 2024 it has happened. This is the case.
Now, 454 cannot be invoked for any previous cases. 454 cannot be invoked for any cases involving an offense of nature which is not covered by the program under the adjudication of penalties. So there is no doubt, it is clear.
But in the past, adjudication notices have been issued even in 1956 Act and other things and all, and people have been actually paid the...
No, not possible at all. There is no power. Legislature cannot be exceeded.
But one thing is that again, coming back to you, sorting out the matter. Why to unnecessarily fight with this and other thing? Let us close the chapter. That is what it seems.
You are entitled to go for compounding. You are entitled to ask a relief from High Court. But how will the adjudicating officer who is supposed to be appointed for this purpose as per the adjudication of penalties rules? So we have to remember there is a decriminalization. From a particular date, the offense has moved from a crime of the nature of offense to a contravention amenable to adjudication of penalties. Now that movement has taken place only after that date. So if it is an offense punishable with penalty, from which date it is an offense, that could be an earlier date. But from which date this provision has come into force is the issue. If you remember, 2014 itself the rules have come for 454 also. But decriminalization took place later on. There are other messages coming one after another.
Yeah, let us see.
Pradhan is writing something, Karthik Varadarajan is writing something. Okay?
Yeah. Okay. Can a sanction of the prosecution be given before the commencement of the alleged offense?
Offense has to be there, then only a prosecution starts.
Correct. Participants like me are really not privileged ones who can actually speak directly to the legal limitation like Dr. KSR on this webinar. Bala sir, give me the citation of this particular case of the non-appointment of the CS, etc., where the ROC has actually split the case, asking for the compounding of the adjudication. Yeah, I'll give you the case. That case is actually there. I remember this actually case is passed by the ROC of Hyderabad actually. This is actually 27th November 2024. It is Virupaksha Organic Limited. That is the case. This is under section 203.5. That is what the section is there. This is the non-appoint of the company secretary and CFO. He has done actually in fabrication. Under 383 of 1956, he said go for compounding. And after that, he has actually levied the penalty. The penalty levied was something around closer to 80 lakhs, I think so. Yeah, that is the case. Yeah, I think questions have been actually done with.
Also 1 o'clock.
If anybody wants to raise their questions, hands and all, they can ask the questions. We can allow them to speak actually. Yeah. Anybody like to ask any questions, etc.? Do you have? Please raise your hands, please. One more thing has come. Many ROCs are actually giving the benefit of adjudication to the direction given even after offence was prior to 2018 notification, assumption to the benefit given to the director. Yeah, that is what it is happening. Yeah.
Bala, let us give a script to Dr. Ravi's time, and I think we may conclude this because almost all the questions he has answered.
Yeah.
And explained the provisions also. I mean, and okay, I told in the beginning itself, he is the subject, he is an authority on the subject, which he has proved it once again, without any doubt.
Excellent,
okay. Thanks very much, Ravi, from
excellent.
my side, for accepting our invitation, and we will have the privilege to have you one more time in future. I mean, whenever the relevant topic is there for that. Thanks once again from my side and from the Mehta and Mehta also. Thank you.
Ravichandran, excellent deliberation. Very nicely you are actually given. It is really, really, enlightening. I am very sure. Definitely now also you can see almost about 135 people. They are patiently there even at 1 o'clock. Normally, this sort of the seminar, what happens is at the end of the time, we hardly see the participant by the time they leave. But it shows very clearly what is the importance of topic, the way you are articulating, you are experiencing, your explanation. Very great, Ravichandran. After a long time, I'm able to see you and hear you. We are only meeting on the online. I think sometime we should meet personally also. When I come to South, I'll give you a call.
No,
Thanks a lot. Thank you so much.
Thank you,
just before you conclude, Bala, that I once again reiterate that next week we are going to have the 32nd webinar on this masterclass, which is going to be the last webinar. Almost 8 months and 3 weeks, which has taken for the last 8 months and 3 weeks, we are conducting these webinars on Companies Act exclusively. I think this is the first venture which we have started. And in fact, on 6th April, when we have started, I never thought that it will go like this. And next week is going to be the concluding webinar. So I request all the participants to attend with adequate preparation so that we can have a good webinar. That is going to be on the miscellaneous provisions of Companies Act, especially the section 447 and 448. We are going to have another good panelist for that program also. Thank you very much.
Ravi, one more thing. You look the same what I have seen you 20 years back. Excellent.
Bala, I must say, I tell you that in fact, when I met Mrs. Ravichandran for the first time, I asked her the question. This was about 5-6 years before. I asked her the question, "कौन सी चक्की का आटा खिलाती हो?"
No, he looks the same.
Not only his physical fitness, but mental agility, but the kind of warmth and affection what he shows towards his friends. This is really commendable.
He actually came to National Convention in Bombay. I think it was held in Ayat along with his partner. I think Madhusudan was there. One more partner there was. They were all actually there. From that time onwards, I am seeing it. The personality is the same, Ravi. You are maintaining. Excellent.
Thank you.
Great.
Right.
Okay. Bye. Thank you.
Thank you. Thanks a lot, Ravi.
Thank you. Thank you.
Thank you. Thank you very much, everybody.
I think also excellent presentation from your side.
Absolutely.
Give it up.